All right, everyone. I think we're about ready to be able to get started here with our 10 o'clock docket. I've got several folks on. Some of them have been on for a little while because um, my understanding was that we were going to try. We had talked to the jail in Hardin County, and they had asked if we could start the proceedings early because they needed to get out in 15 minutes and go to have a family court hearing. So I started this about 20 minutes ago, but Hardin County's not ever logged in. So I don't know if they're not going to log in at all or if they just forgot that they were going to log in early.
I don't know. We do have an agreement in that case though, Judge, so.
Well,
So
I know
whenever-
that Mr. McGee, his client is in Hardin County. I keep saying the wrong county, I'm sorry. And I believe that, that conceivably we haven't spoken anything at all about that case. So this is the first time I think Mr. McGee has appeared in that case. So I don't know if there's going to be some sort of agreement about it. Your motion is to have an evaluation done, but I don't know where we are on that. And it's certainly something we could do without her if we're willing to do it without her. But
yes, sir. And we could, given the nature of the motion, and first of all, good morning, Your Honor. Given the nature of the motion and the information that my office obtained in support of that motion, I don't think that we would necessarily need Ms. Bryant for today's purpose, Your Honor. But we would ask the court to go forward on that.
okay, let's, for the record, let's just go ahead and call that one and do it. 20 CR 15. That's Jessica Bryant. As mentioned, this is, and I think Mr. Richardson's gotten on. Yeah, there he is. This is Mr. McGee's motion on behalf of Ms. Bryant for a mental health evaluation or a competency evaluation. Mr. Richardson, I don't know what the Commonwealth's position is going to be on that.
Well, I talked to the prosecutor in Louisville, Judge, because right now she's facing a revocation up there. And I think ours was the only case where this was filed. But I'm not going to stand in the way. I think we can get her evaluated ASAP to get that out the way. I don't want to hold up her revocation too much longer. So we're agreeable to have her evaluated.
Does she have a hearing pending?
In April, she has a revocation hearing set in Jefferson County.
That's correct, Your Honor.
All right, very good. I'm rearranging my speakers so that I can get better. Sorry about that. All right. Yeah, so the motion looks like, it's a fairly simple situation where I could have her sent to KCPC because she's in custody. I don't know if that's, Mr. McGee, I guess the big thing here, having looked at your motion, the big thing that I would be concerned about is whether or not I can actually dictate to them what tests they run or what metrics they use to make that determination. I think I can certainly suggest it. I can certainly say that you've requested that those tests get done, but I've not ever, specifically ordered, a given test to be done. Does that make sense?
It does, Your Honor. And I appreciate the court's concern. What we're asking KCPC to do as part of their assessment is add this to the battery of examinations that they do, Your Honor. This inventory only consists of about 195 questions. It's much shorter than the other inventory that they had previously used. And it's a more up-to-date inventory, Your Honor. This is based on a 2015 examination that was adopted by the APA, and it's consistent with the criteria in DSM-5. So it is one that they're familiar with if they can include it in their battery. And I know the court may not order it, but if the court can recommend it, Your Honor.
All right, very good. Let me say, I believe Hardin County just jumped on here. So if you all have Miss Bryant, there, if you can bring her up to the camera.
Yes, Judge.
There we go. Miss Bryant, good morning.
Good morning, Jessica.
Good morning.
We were speaking to your attorney, Mr. McGee, about the motion that is pending. That is a motion to have you assessed for competency and also for any sort of opinions about capacity, which the Commonwealth is not taking a stance in opposition to. So I'm going to go ahead and order that, and we'll let them know at the facility that you are in Hardin County Jail, and they'll be in communication with those authorities there in Hardin County so that they can get this thing worked out. Okay.
Yes, Your Honor.
It would seem like to me that just so that we don't lose things in the shuffle, a good idea would be to set this for another pretrial. And I think,
Yes.
I have no idea what the waiting periods are for Hardin, or I'm sorry, for KCPC right now. Normally, we need to put them out at least 30 days. It might be a good idea to put this one out even further than that, but I'll listen to what anybody has to say about it.
Well, I think that's wise counsel, Your Honor. If we could go, if Mr. Richardson has no objection, if we could go 60 days, Your Honor, I think we'll have a copy of the report back by that time and have an opportunity for counsel for the respective sides and the court to review it, Your Honor.
Okay.
Judge.
Yeah. All right. Yeah. 60 days or 30 days is usually just the, bare minimum. So 60 days is probably a better idea. That looks like let's call it May 17th.
Yes, sir.
So I'm going to reschedule the pretrial conference for May 17th. Now, normally we do those at 1 o'clock in the afternoon. When May gets here, I anticipate that we'll be doing most, if not all, of our proceedings in person by that point. So,
Yes,
I'm hoping that we don't have to worry about people's jails, Zoom schedules and things of that nature to the same extent, although there is some legislation pending that might make us have to do all of these by Zoom. So who knows where that'll go. But if nobody objects, I'm going to put it on the 1 o'clock docket. And then as we get a little bit closer to it and we communicate with the jail, if that doesn't work, we'll get with everybody and maybe change the time. Okay.
Yes, Your Honor. That's fine, sir.
All right. So that'll be 1 o'clock, which is Central Time. So of course that's an hour behind the Louisville time. Okay.
Yes, sir. Yes, sir.
All right. I'm going to take care of that. And, hopefully we'll all have our reports back when that day gets here. Okay.
Thank
Very much appreciated, Your Honor. Thank you, sir.
Thank you. Josh, did you say that there was something going on in Mr. Wolf?
Yeah, we have an agreement, Your Honor. I think Mike just e-filed it.
I did.
Oh, okay. Can you all grab that real quick and print it? David Wolf, because I won't get it. All right. Hello, Mr. Wolf.
Hello, sir.
Let me shift gears here and get you on the camera. And then I'm gonna try to look your e-filing up so we can get started. Mr. Wolf, it's my understanding that you have got an agreement in your case. Do you agree with that?
Yes, sir.
All right. Can you raise your right hand for me, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Yeah. Yeah, the problem when these things get e-filed at the last second is if there's not somebody sitting there in the clerk's office accepting them, they're not open for public view. And the clerk that would normally be doing that is sitting in here recording these proceedings. So I don't have anything.
I can email it to you right now, Judge.
Yeah. Okay. That'd be great. I mean, I'll get it all, ultimately, I just don't have it right now. All right, Mr. Wolf, I can go ahead and proceed with part of this. And then as we move on through, I'll have to pause and pull that email up and take a look at it. Okay.
Yes, sir.
All right. First off, now that I have put you under oath, are you representing to me that you have reached an agreement that will involve you entering a plea of guilty?
Yes, sir.
And do you understand that that must be a voluntary decision on your part? In other words, you cannot do that just because you think I'm trying to make you do it or anyone else is trying to make you do it.
Yes, sir.
All right. Mr. Wolf, do you understand that you have the right not to incriminate yourself? In other words, you do not have to admit guilt or otherwise say anything that would prove the charges against you.
Yes, sir.
All right. You have the right to a trial by jury where the Commonwealth would be responsible for proving guilt beyond a reasonable doubt. Do you understand that?
Yes, sir.
Okay. You understand that you have the right to confront and cross-examine the people that give evidence against you at trial.
Yes, sir.
You have the right to put evidence on in your own defense at trial.
Yes, sir.
You have the right to appeal the outcome of the proceedings to a higher court.
Yes, sir.
Okay. Do you understand that you waive each of those rights if you plead guilty?
Yes, sir.
I printed all that stuff. I just sent it to the printer. Yeah. Well, I know, I just now did it. Mr. Wolf, today, do you feel like you are under the influence of anything?
No, sir.
You feel like your judgment is impaired for any reason?
No, sir.
All right. Now here's where I'm going to have to pause until I can get the paperwork. Mr. Richardson sent it to me. I sent it to the printer. Somebody's got to run in and get it. Okay.
All right.
Because I'd like to be able to, I mean, I can read it, but I'd like to be able to show it to you to verify that you've seen all the papers. Okay.
Yes, sir.
All right, here it comes. Thank you. All right. So first off, I'm going to show you this page. This is your motion to enter a guilty plea. Does that look familiar to you?
Yes, sir.
All right. And on the second page, there is a signature. Is that you?
Yes, sir.
All right. And did you read over this and discuss it with your attorney before you signed it?
Yes, sir.
All right. This is your offer from the Commonwealth. And I know I'm kind of doing it fast, but does that look familiar to you?
Yes.
All right. And again, there's a signature page on there. Does that look familiar?
Yes, sir.
All right. Did you read that and discuss it with your attorney?
Yes, sir.
All right. So do you confirm, Mr. Wolf, here today that you understand both the motion to enter a guilty plea and the terms of the offer from the Commonwealth?
Yes, sir.
All right. Thank you. Mr. Wolf, in that offer, your charges and the recommended sentences are as follows. Count 1, theft by unlawful taking, $500 or more. That is a Class D felony. On a guilty plea, the Commonwealth would recommend a sentence of 3 years plus a possible fine. On count 2, possession of controlled substance, first degree, first offense, another D felony. On a plea of guilty, the Commonwealth would recommend, again, a sentence of 3 years. Those two sentences would be concurrent with one another. Count 3, persistent felony offender in the first degree. That would be a sentence enhancement, but the Commonwealth has agreed to dismiss that on the plea of guilty to the other two charges. Therefore, the total recommended sentence would be 3 years, and the Commonwealth would oppose probation of that sentence. The 3-year sentence would be consecutive with any prior sentence. Do you understand the agreement the same way that I've just expressed it to you?
Yes, sir.
And do you believe that is, in fact, the agreement you reached?
Yes, sir.
Have you been threatened with anything to try to get you to reach that agreement?
No, sir.
Have you been made any promises other than the promises that the Commonwealth is making to recommend those sentences if you plead guilty?
No, sir.
All right. Mr. Wolf, do you feel like you're being forced or compelled against your will to enter this agreement?
No, sir.
All right. Are you acknowledging to me here today that on October 13th in the year 2019, Barron County, Kentucky, you committed the offense of theft by unlawful taking when you unlawfully took or exercised physical control over movable property belonging to Walmart valued at $500 or more, but less than $10,000 with the intent to deprive Walmart thereof?
Yes, sir.
Are you also acknowledging that at that same time and place, you knowingly and unlawfully possessed hydrocodone constituting the offense of possession of a controlled substance first degree?
Yes, sir.
All right, Mr. Wolf, I am going to accept your plea of guilty today to those charges. Have you all discussed whether you want to be sentenced today or do you want to be sentenced after a PSI at a later date?
Judge, oh, go ahead, David.
We'll go ahead and be sentenced today.
All right, sir. Mr. Wolf, based upon your guilty plea, which I hereby accept as having been entered freely, knowingly, intelligently, and voluntarily, I am going to accept the agreement that you have reached with the Commonwealth and sentence you to 3 years on count 1, the theft charge, 3 years on count 2, the possession charge. Those sentences will run concurrently with one another for a total sentence of 3 years. I will waive your fines and your court costs because the Commonwealth is opposing your probation, which means you're going to at least be in custody for the immediately foreseeable future. And I think it's unfair to ask you to pay the fines and court costs. I mean, if I imposed them, I'd have to give you credit on them, so you'd serve them out anyway. Okay?
Yes, sir.
All right. Your sentence in this case will be consecutive to any other sentence that you already have, if there is any, and I don't know that there is. But that's about all there is to it. Do you have any questions?
That'll be it, sir.
I'm sorry?
That'll be it.
All right.
No question.
Good luck, sir. Okay?
You too. Have a nice day.
All right. Thank you. I believe that's got us taken care of with the Hardin County Detention Center. So thank you.
Yes, Judge. Thank you for your time.
All right. Let's see. I don't think I have any other jails on this morning. We've got several on this.
Judge, we have the Taylor County Jail
Taylor
on.
County. Yeah, I'm sorry, Taylor County. Yeah, there he is. He's been here for a minute too, and I forgot all about him. Apologies.
That's okay.
Yeah, it showed up on my list that this was a 1 o'clock case, but it is on the docket for 10, and you're here at 10, and everybody knew it was 10 but me. All right.
Judge,
This-
this is Miss Myers's case, and she is stuck still in a case in Warren County.
Okay.
Your Honor, I had spoken to Miss Myers. I don't know if she had talked to Mr. Blair. I'd extended an offer. I received a counter offer that I need to discuss with the victim and the family in this case before it's something I can accept on behalf of the Commonwealth. So I talked about maybe putting it out 2 weeks. And hopefully we'll have either know we have a resolution or not by that time.
Okay. I mean, I think that's doable. We can, Mr. Blair, is there somebody there with you that from the detention center that can answer a question?
Yes, sir. Yeah.
All right. 2 weeks from today would be the 29th of March. And I'm just wondering if there's anything they might know of right off the top of their head that would make that a bad day for us. If they don't, then we'll put you off to that date.
The only thing we have is, regular district court like we did this morning.
Okay. So if we tried to do this same time, will that work for you?
Yes, Your Honor.
All right. Very good.
Your Honor,
Yes, sir.
me and Ms. Myers, we talked about trying to do something with my bond because I'm going up for parole and I should have a shot hearing coming up soon.
I don't believe he's eligible. I believe until sometime in April.
April the 1st.
Yeah.
So
Well,
if we're on the 29th,
Yeah, we'll get back here before that date. And then if we have an agreement, fine. If we don't have one, then I'm sure she'll want to talk about your bond, and that'll be fair. Okay.
Yes, sir.
All right. So that's March 29th at 10 o'clock a.m. For the benefit of the detention center there. It'll be the same link that you've used for this hearing, but we will send you another email invitation so that, for calendaring purposes. Okay.
Okay. Thank you, Your Honor.
Thank you very much. See you in 2 weeks, Mr. Blair.
Yes, sir. Thank you.
All right. Let's see now, of course, we've got Barron County Jail on now. So if there's anybody that we need to do out of order or anything like that, we can take those up or
Your Honor, we do have Ms. Faith with DPA in Owensboro on Miles Pruitt. We have a hearing on his bond revocation.
Gotcha. I think, has that got Miss Atkins in it?
It does.
Okay. She was doing a hearing with family court, but I think she's also, I mean, I see her iPad on here, so she's available, or at least will be momentarily.
Judge, she'll be with you just in a moment.
Okay, thank you.
Mhm.
And Judge, this is Catherine Faith with the Owensboro DPA.
Yes,
And
ma'am.
I'm asking, is the Miss Atkins the witness for the Commonwealth regarding the violations of bond?
Yes, ma'am.
I believe after speaking with Mr. Pruitt, I believe we were willing to stipulate that there were occasions that he did not attend.
The problem is, Your Honor, we are dealing with social services too. She
Okay.
just tested positive.
Yeah, I'm hearing Julie's in the background over there. All right. Yeah, let me get you back on here, Miss Faith, and I'm gonna put you on speaker view up here so that you're, all right. Can you repeat what you were saying, ma'am?
Yes, Judge, I think that we're willing to stipulate that there were occasions that Mr. Pruitt did not report for drug testing per U-turns, I think is the provider for that.
Yes,
He's
ma'am.
not contesting that this morning, Judge. Instead, that he would like to offer testimony about the circumstances of why he might not have reported during those times and reserve the opportunity for me to speak on his behalf.
Okay. So basically, we have a report from the U-turn office that shows that he had missed tests in September, October, one each, January, 2 in January. And so he's stipulating to that, basically.
Yes, Judge, if we can have confirmation from Mr. Pruitt that he heard that and that he is in agreement.
Oh, Your Honor, correct me if I'm wrong. I don't believe that's entirely accurate because we filed this motion, I believe, back in June of last year and never had a hearing on it. So it goes back until June of 2020, which June 9th of 2020, there is a positive for marijuana, a no-show on June the 26th. And on July the 1st, there was a positive for marijuana and meth that was lab confirmed. And then from that point on, there was a multitude of no-shows.
Yeah, I was just looking at the last report, and you're right. There was a previous report that was the subject of a motion, and then we ended up not being able to do it because that was the day, it was set on the day that we ended up shutting everything down and not having court because of the numbers. So, and we haven't been back in open court since, in-person court, rather. Yeah, so basically, he would have, of course, we've got Miss Atkins on here now. She's available, so I don't know if it might, just to avoid the confusion, it might be better to just allow her to testify about her things, and then that way Mr. Pruitt can say what he wants to in response. Miss Atkins,
Yes, Judge.
do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, thank you. Will you state your name for the record, please?
Julie Adkins,
And how are you employed?
with the U-turn program.
Okay, Miss Gardner, you may ask her.
Okay, thank you, Judge. Ms. Atkins, you've been supervising Miles Pruitt for his bond.
I have been since February 4th of last year.
Going back to June of 2020, were there some violations of his bond conditions in regard to his drug testing?
There were, we filed a violation report. We had a positive test for marijuana.
Can I stop you real quick? I'm having a hard time. I think Mr. Garrett's not on mute.
Yep, there we go.
Okay. We did have a positive marijuana test on 6/9 that we filed that violation report for.
Were there any other violations in the month of June?
He was a no-show on 6/26. And then following that, we filed violation reports 1, 2, 3, 4, 5 times to date, following that for continued mistest.
Was there on July the 1st, did you file a report, or was there an occasion that he failed or he did report for a test and then it was positive for substances?
It was on July 1st of last year. He tested positive for methamphetamine and marijuana use.
Was that the last time he appeared?
And we sent that to the lab, and and the lab did confirm that use.
Was that the last time he showed for a drug screen?
It is.
And at any time, did he give you a new number or new contact information for you to?
No, we've not been able to reach Mr. Pruitt since that time. There's been no contact with him since that time.
How often had you attempted to contact Mr. Pruitt since that time?
I could read those dates off to you, but on the average, it's at least twice a month. Would you like those dates?
No, I don't know if that's necessary if you know it was twice a month, and I think that was in the attachments to the motion. When was the most recent time, if you could tell the court, that you attempted to contact Mr. Pruitt?
On February the 25th, we called the numbers that were provided, and both numbers we were able to leave. I'm sorry, their voicemail was not set up on one number, and the second number was not accepting calls.
When you had called previously, was that the same issue, or were you able to leave messages?
Let me look back. Back in January and December at one number, we would get a continuous ring and there was no opportunity to leave a message. But at the second number, it was not reachable, voicemail not set up. So
those were the numbers he provided to you?
Yes.
I don't have any further questions, Judge.
I'm sorry.
Oh, no.
Those numbers were his girlfriend's number and his cell number.
All right. Cross-examination?
Thank you, Judge. Ms. Adkins, what was the phone number you had for Mr. Pruitt?
I'm sorry, you were breaking up. I didn't hear all of that question.
Sorry, please let me know if my signal prevents you from being able to understand me. What was the phone number that you had for Mr. Pruitt when he began testing with you in June?
The numbers that we have on file are his cell number is 270-576-0625. And then we have 270-576-0684.
And you believe those, one to be his cell phone and the other one to be his girlfriend's?
Yes.
All right. And I'm going through, you said you had filed 5 no shows in addition to a positive drug screen. I'm looking through here. If you said that you had attempted to contact him twice a month during the time that you were supervising him, in the month of November, did you either attempt to reach Mr. Pruitt and or did he appear for drug testing?
In November, we were not testing because of COVID. We were shut down.
Okay. And the phone numbers that you had for Mr. Pruitt for any calls in this year, so 2021, did you have the same numbers you had in June?
I'm sorry. I think your question was that you were really breaking up, but I think your question is, do we have the same numbers?
Yes. the numbers ending in 0625 and 0684.
With the Commonwealth Attorney, with the Sheriff's Department and all them, it was being held for something that didn't even happen, like something that was supposed to happen in Breckenridge County.
There's a lot of background noise. I think I understand your question.
That's Johnny.
Yeah. We've just started doing these Zoom hearings, so he didn't know how to mute.
I'll just ask my question over, Ms. Adkins, if you're able to hear me now.
Okay,
You had stated that you did not drug test in the month of November.
that's
and
right.
And I had asked, in the year 2021, did you have updated contact information for Mr. Pruitt?
I haven't had any contact with Mr. Pruitt.
Okay, so it's the same phone numbers you had back in June.
Those are the numbers, yes.
Okay. And can you remind me of the date that you last had Mr. Pruitt in your office?
We last tested him on July 1st, 2020.
Okay. And is Mr. Pruitt ineligible for future screenings if the judge were to allow him out of custody?
That would certainly be up to the court.
Okay, but if the court did allow him out, there would be nothing stopping him from participating in your program?
Certainly, if the court should so order.
And do you have logged any times that you might have left voicemails?
I'm sorry, again, please.
All right. Do you have noted or annotated when you might have left voicemail if you were able?
Okay, let me look back.
You're paid up with us on the insurance case.
On January the 29th, we called, and a gentleman by the name of Robert Stockton called us back on and reported that he would relay the message of the drug screen to Mr. Miles.
And did he, sorry,
He
are you
was-
able to hear me, Ms. Adkins?
I can.
Did he provide any information about who he was in relevance to Mr. Pruitt?
He did not. He answered at the 576-0684 number.
Hmm, okay.
Prior to that, on September 11th, someone answered the 0684 number and hung up. But other than that, that's the only answers that we've had.
That's my father's number.
Mr. Pruitt, just remain silent for now until it's your turn to speak, and you'll be under oath and able to provide more information, okay?
And then again on October the 27th, we did actually, at the 0684 number, we did actually speak with Mr. Pruitt, and he was a no-show on that day.
Can you tell me that date again, Ms. Atkins?
October 27.
And can you tell me the city that your testing site is?
We're in Glasgow.
Glasgow.
Mhm.
Is that all the notes you might have? I didn't mean to cut you off.
I was just trying to answer what question about any contact that we'd had with him.
Would that surmise it?
Pretty much.
Okay. Judge, I don't think I have anything more at this time.
All right, any redirect?
I just have one question, Ms. Atkins. Those two numbers that you had, were those the numbers you used when Mr. Pruitt did show up on June the 9th and July the 1st?
They were.
No further questions.
Okay. Is that it for Ms. Atkins?
It is, Your Honor.
All right. Is that it for the Commonwealth?
It is.
All right. Is Mr. Pruitt testifying?
Judge, I believe so.
Okay. Mr. Pruitt, raise your right hand, please. Do you swear or affirm your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Thank you. Ms. Faith, you may ask him.
Thank you, Judge. Mr. Pruitt, are you able to hear me clearly?
Yes, ma'am.
If I become unclear at any point, please let me know.
Yes, ma'am.
Now, do you understand why you're here today?
Yes, ma'am.
Okay, why?
For not accepting my responsibilities, and missing my drug test.
Okay. Now, tell me, you attempted to say something about a phone number of 576-0684 earlier. Is that right?
06. Yes, sir. Yes, ma'am. That's my father's number. I didn't have a phone at the time.
Okay. And was that a landline, a cell phone?
That was his cell phone. But my dad's 68, and sometimes he don't answer the phone, and he forgets to, to let me know whenever they had called. I remember he had let me know on I think it was on a Monday, and then he told me that they had called. I think it was a Thursday, but he told me that they had called on a Monday, but he forgot to tell me. But
What is your father's name, Mr. Pruitt?
Robert Stockton.
Okay. And you said that he's in his 60s.
Yeah, he's 68 years old.
Were you living with your father during the later half of 2020? Sorry, I'll re-ask my question, Mr. Pruitt. Were you living with Mr. Stockton, your father, during the later half of 2020?
Yes, ma'am. I'm still living with him now as we speak.
Okay. And why were the U-Turns people unable to reach you?
Because I didn't have my phone number. I didn't have a number, and my dad, when they called my dad, like I said, he would forget sometimes, or he wouldn't answer the phone. But
Okay.
the times that he did talk to him, he had told me like a day later, and I didn't have a cell phone at the time.
All right, so let me be clear. The phone number ending in 0684, that's your father. So the number ending in 0625,
Yes, ma'am.
whose phone number is that?
My girlfriend's phone. That was my girlfriend at the time, and that's the only phone numbers I had contact with, because whenever I went to jail, my phone number got cut off. So whenever I was released, I didn't have a phone number to get contact with anyone but those two numbers.
When did you break up with your girlfriend?
Probably, it's been a year, right? Close, like as soon as I got out, about the time I got out.
So sometime in 2020.
Yes, ma'am.
All right. You have a new girlfriend?
Yes, ma'am.
Are you using her cell phone for any purposes while you're out of custody?
I have my phone. I have a phone number, and I use her number and my number, and we just had a newborn baby December 15th.
Okay. You said December 15th?
Yes, ma'am.
All right. Now, you understand that you were under pretrial supervision, right?
Yes, ma'am.
And you understood that part of that was drug screening.
Yes, ma'am.
Okay. Can you please tell the judge why you didn't do what you were told to do?
Because I accept my responsibility for not going up there, and I'm sorry for that. And I've learned my lesson. I promise you that. And I just had a newborn kid, and it's changed my life. And I know I've been helping my dad because he's got real bad breathing treatment. He can't even fix a sandwich without breathing. And I've been helping my father a whole lot. And my girlfriend stays with us too. And I got off track, but I was whenever I got out, I was on track though. I went and took my test like I was supposed to. And whenever they called, I was answering, and I was getting to the phone. But like whenever I'd ask my dad, he would tell me that they called. It'd be like a day late. And I didn't, and it was my fault because I should have took myself up there and checked in too. I should have went ahead and went up there, even though I missed, instead of not calling. and waiting for him to call me back. I should have took myself up there and put forth my effort in doing what I was supposed to be doing. And I'm sorry for that.
So I'm going to summarize that. You tell me if I'm correct. Your father has issues and you're helping him when you live with him.
Yes, sir. My dad has cancer,
Okay. What kind of cancer?
colon cancer. And he had his breathing is a whole lot bad. Like he can't even fix a sandwich without breathing, without stopping to breathe. I have to help him.
And you're part of his caretaking?
Yes, ma'am.
Okay. And then you just had a baby born in December.
Yes, ma'am. Named Naomi Jordan Pruitt.
Okay. And how long have you been incarcerated as of today?
It'd be 13 days, 13 days.
Sometime between 10 and 13 days. And has that shifted your perception on what it means to be on pretrial supervision?
Yes, ma'am. Totally. It totally has. I don't never want to be here again. And if I get the chance to come out, I promise you, they'll never see me in front of this screen again or in front of the judge.
Except for when the judge tells you to, right?
Yes. I will abide by everything I'm supposed to do, and I promise you, I will accept every responsibility that I'm supposed to have.
And did we have a
And I'm sorry for the
conversation?
stuff that I had. Yes.
And did we have a conversation last week? Do you recall?
Yes, ma'am.
Did
Yes,
I
ma'am.
explain to you what the
You was really-
repercussions
you was
would
highly-
be? Please
Yes, ma'am.
go ahead, Mr.
She was
Pruitt.
really mad at me. Yeah. She told me that I had to accept my responsibilities and that there's no way around it because I'm shooting myself in the foot. If I'm given these chances to be a better person on the outside, then, and if I can't go to U-turn and take my drug test, then how am I going to do it on probation? And it does make sense. And like I said, I sincerely apologize. It will never happen again. I can go take a drug test today as soon as I leave if I get released, and God's willing. But at the same time, I accept my responsibilities, and this will never happen again. And I'm sorry for it to because I know it's a problem on my end, but I'm making it a problem on y'all's end too.
My question, Mr. Pruitt, was, do you understand the repercussions of not following court orders?
Yes, ma'am. Jail time.
Okay. Now, that's all the questions I have at this time. The Commonwealth may have some, Mr. Pruitt. I'm going to admonish you, though, just don't speak about any of the facts relating to your case that's pending. Do you understand?
Yes, ma'am.
All right, Ms. Gardner.
Yes, Judge. Mr. Pruitt, you had just testified that your dad did let you know that there were times Ms. Atkins had contacted you, but it was just a few days later.
It was a few days later, and I didn't get.
And then you did not,
I
Mr.
didn't-
Pruitt, you didn't contact Ms. Atkins back. That's correct?
Whenever I called, that's whenever the COVID was going, and they was shut down at the time.
In November?
Yes, ma'am.
Okay, so you waited until November to call.
I didn't wait till November. It was that time whenever they called, it was around that time of the virus, whenever Dad had told me that part. The other ones.
Mr.
I
Pruitt,
missed.
you do remember last summer you did come to court when you
Yes,
were
ma'am.
aware of the issues with you reporting. Do you recall back in September telling the judge in court that you had some new contact information and that you were going to provide that to Ms. Atkins?
Yes, ma'am.
And you did not do that.
No, ma'am, I didn't. I'm sorry about that.
You at no time updated any kind of contact information with Ms. Atkins.
I thought when I went and took my last drug test, I thought I had gave her my new number, which was the 270-861-9227. But
you didn't.
no, ma'am, I didn't. I didn't.
Okay.
But she said she's only has 576-0684, and that's only my father's number.
You do realize it's your responsibility to get that information to Ms. Atkins.
Yes, ma'am. I'm sorry.
When did you say that your daughter was born?
December 15th.
December 15th. And you would acknowledge you were served with a warrant on your arrest for bond violations on March the 4th.
Yes, ma'am.
And you were with a co-defendant in this case, correct?
Yes, ma'am. My sister was.
And you,
she's
no,
on my.
let me ask, Mr. Pruitt, you're also with another individual who was found in possession of meth. Correct?
No, I wasn't
Judge,
with
I'm going to enter an objection as this information has
No,
not
ma'am.
been made known to me. in the motion, I don't believe it indicates.
I'll withdraw.
I was gonna
co-defendant.
look at, yeah, all right. Yeah, we'll move on.
I don't have any other questions, Judge.
All right. Redirect.
Mr. Pruitt, after this
Yes, ma'am.
conversation, after your testimony here, is there anything else that you want the judge to know when he is considering whether or not to allow you out of custody pending your case being resolved?
Mr. Alexander, I take my responsibility to the utmost high. And I promise you, you will never see me again. I put this on everything I love. That's all I can do. I can put that, and I can be a man to say, I'm sorry and I accept my responsibilities, but this is not me. This is not me. It's never been me. I've always been good. I've always did what I was supposed to do because my mama raised me right. If you give me one more chance, that's all I can do is prove to you. I know a lot of people say, he say, she say, and a pair of lips will tell you anything, but from the bottom of my heart, I just want to be with my daughter. And I'm afraid I might lose my dad and I don't have my mom and him no more, and that's all I have is my father. And I'm trying to be there to help him. And like right now, it's only my daughter and my girlfriend and my dad at home. You know what I'm saying? Like my girlfriend's trying to help my dad as well as be with my daughter and help her too. And she needs help. She's having technical difficulties with a lot of stuff. And I'm trying to tell her on the phone to be strong when I know I'm as a man, I need to take my responsibilities and be there. And I promise you, this will never happen again. I'll go every day. If Julie calls me on Monday, and I go take a test on Monday, if she don't call me that upcoming week, I'll walk up her. Even rain, sleet, or snow, I'll walk. Even if I don't have a car, I'll make sure I make it up there, sir. And I got new information for my phone updates. I got a phone. My girlfriend's got a phone that's going to stay on forever. And
Mr. Pruitt.
I got. Yes, ma'am.
Is this the first time that you've been in custody since the case began in 2019?
Yes, ma'am.
Okay, and you've been in between
ma'am.
10 to 13 days?
Yes, ma'am.
Okay, and then also what I think you were saying was that if you get a call from Miss Adkins, you're
On a Monday,
there.
I would just pop up on Thursday and ask them if they need me to pee again.
And if all your phones are shut off, and you have no access to phone,
I will make sure I walk up there and give her and see her face to face to make sure I need to take a drug test. This will never happen again, sir. And I'm sorry again, because I know, like I said, it's inconvenience on me as well. It's hurting me more than y'all, but at the same time, it's a problem with y'all. You know what I'm saying? It's making a problem for y'all too as well. And I'm sorry for that. I sincerely apologize.
Okay.
I think that's all I have, Judge.
Ms. Gardner, any other questions?
I'm sorry, Ms. Gardner.
Hold on, Miles. Any questions, Ms. Gardner?
No.
All right, fair enough.
Sorry.
Yeah. I mean, let's hear what your arguments are. I think he's already made it, his argument, but you can sum up.
Yes, Judge. Mr. Pruitt had indicated that I was mad at him when we spoke last week, but the case was actually, Judge, that I was using the full gravity of the situation of what he had been doing for the last 6 or so months and how he's conducted himself in regards to being on pretrial release, so that hopefully he would grasp what could happen to him were he not to follow your order. In addition to that, Judge, I hope and believe that he is sincere and that, he's willing to walk there every day if that's what it takes to remain in compliance. This is his first time being in custody since the initial arrest. And all of that, plus, Judge, the fact, if you look at his pretrial interview, the one that's been updated on March 5th, he is a moderate/low risk. And as to the moderate, Judge, if you look through there, the indicated is a score of 2, and the 2 comes from a failure to appear in a traffic case back in 2018, and the fact that he's had 1 prior misdemeanor conviction, and that's it, Judge. The other low score, 1 as well, and I think his criminal history speaks in his favor. That pretrial interview speaks in his favor. The sincerity of his statements today, Judge, I believe also speak in his favor. And we would ask you, Judge, to consider releasing him back on bond with credit time served and or unsecured judge. That way, Mr. Pruitt can get doing what he's supposed to be doing while Ms. Gardner and I hopefully attempt to resolve his case so that he can come to the table and resolve this the next time he's in front of you.
Okay, Ms. Gardner.
Your Honor, I think that the proof shows Mr. Pruitt can't follow his bond conditions. Going back until June of last year, he had 2 separate positive drug screens. Mr. Pruitt did appear in court on 2 separate occasions. I believe once in August, and then on September the 28th. On both of those occasions, Mr. Pruitt was made aware of the pending bond revocation motion due to his failure to report to U-Turn. And on September 28th is when he had said that he had new contact information that he needed to provide to Ms. Atkins. Ms. Atkins testified that at no time had that information been updated, that the numbers that she had used early on that worked when he did show for drug screens were the ones that she continued to use. Between his August court date and his September court date, there were 4 no-shows. The simplest thing he could do was to have reported. He said that he got the message that Julie called, but he never, ever called back and said, hey, I just found out you called a few days ago. This would have taken care of this whole situation. Instead, he continued to not report, and we've had to get to this point where we have a bond revocation hearing. I think that there's cause to have his bond revoked, and we'd ask that you do so.
Yeah, listen, here's the situation. And I'm calling you Miles because I've known you a long time. And you knew better than what was going on here. And you knew that you were supposed to go in there. I'm not, you don't have to apologize because nobody's mad at you. That's not how this works. I mean, this is not a personal thing at all. But you shouldn't need getting arrested on a warrant and then having to go to jail for 10 days for you to know that you're supposed to comply with what the judge tells you to do. Any judge, including me, but any other judge. And when you get out on bond, and then when we're in court and we address that you've got these issues you need to straighten out, and you don't go straighten them out. Here's the thing. All right. I mean, this is not, and I appreciate your attorney's arguments because, I understand what they are and I understand why she's making them. But this is, 2 Class B felonies. This isn't not appearing on a speeding ticket or a no license or whatever it is that you had back, 3 years ago. These charges are exceedingly serious, at least as they stand right now. And, I tend to think that you just weren't doing, all I've heard proof about was you weren't going in there and getting your test. But I don't know that anything's been going the way it ought to be going. I don't want to make you stay in jail and miss time with your dad. I don't want to make you stay in jail and miss time with your baby. But those are secondary concerns from my standpoint as to you complying with your bond conditions and doing what you are supposed to do. So here's what we're doing. All right. I know you've already been in there a couple of weeks or a few days shy of a couple of weeks. And I'm not putting your attorney on the spot here, but with us meeting by Zoom, I think she can probably accommodate this a lot easier than if we were driving over in person. But I'm going to put you on for a pretrial conference where you and your attorney can have some serious conversations about which direction your case is going. I am not trying to leverage you into reaching some kind of an agreement or anything like that, but I want her, I feel like if she'd have known all this time that you weren't doing what you were supposed to be doing, she would have had whatever conversation that she had with you last week. She would have had it with you a long time ago. All right. So this is time for you all to sit down and metaphorically or otherwise, and talk about your case and see whether or not there's a direction that you can go in where we know what we're doing. All right. And if you all can do that by next Monday, I'll put your pretrial on next Monday. If you can do it within 2 weeks, I'll put your pretrial on for 2 weeks from today. But, I'm going to hold you in custody till you all can have that conversation. And then if we come back in a week or 2 weeks or whatever, we'll talk about your bond again, and I may very well reinstate it. But I mean, better than what's been going on. And that, I accept your apology and I accept your explanation, but your explanation was essentially I wasn't doing what I was supposed to do. And I know I wasn't doing what I was supposed to do. And it takes guts to get up there and say that, which I will keep in mind whenever we start talking about your bond again. But right now, that's not how this works. The Commonwealth put on proof that you violated your bond conditions. When that happens, they get what they're asking for, which is a revocation of your bond until we have your pretrial. All right. So, and listen, I know you got a lot to say. This isn't a dialogue. This is a soliloquy. Okay. I've already said what we're going to do. You've already had your chance to testify. Miss Faith, what Monday can you be back?
Judge, if Miss Gardner and I can get together, I could do the 22nd, which is one Monday from today.
Yeah, that works for me. I mean, I think that she'll be stuck with me all day, but I mean, after today, as far as criminal court calendars, I don't think there's a whole lot going on between now and next Monday. So I think she ought to be able to get with you. Okay.
Yes, Judge.
All right. Mr. Pruitt, I'm going to see you in 1 week. Okay. We'll do 1 o'clock unless Ms. Faith, you can't do that.
That is perfect, Judge.
All right. March 22nd at 1 o'clock.
Monday next week.
Yes, Monday, a week from today. All right.
Okay.
Thank you. All right, Ms. Faith, is that your only case?
It is, Judge.
Okay, you are free to go.
Thank you.
Who's
Judge, I've got Mr. Garrett waiting on Charlotte Woodcock.
Let me warn y'all, if anybody else wants a hearing, we're going to do it on another day because I can't. I've got 41 cases on here. I can't do 45-minute bond hearings on 41 cases in 2 hours. So if you all want to put on any more evidence or anything like that, then get your calendars out and we'll figure out when we're going to do it because we don't have time to do it.
On this
Yeah,
one,
I think the only one judge is that Lorenzo Martin. I don't know who represents him. I think it's DPA. If we could just have an idea of what they want to do.
Yeah, I'm not trying to make it hard on him, but I'm just saying we have 2 hours to do these 41 cases. We can't have these long hearings, so I mean, so that's where we are. If they can be thinking about that and after we talk to Mr. Garrett, are you available?
I am, Your Honor.
All right. What are we doing with Ms. Woodcock's case?
Judge, we're just going to move her to 1 o'clock. Mr. Richardson and I are trying to work that case out. I'm going to go see her at the jail momentarily to discuss a resolution.
Okay. I'll just put these over here on the afternoon pile and we'll see you then.
Thank you, Judge.
All right. Thank you. All right. What's next? Y'all want me to just start going down the list or do you have witnesses for anything else besides that Martin case?
Judge, this is Johnny Bill. I got one arraignment, not in jail. I don't know if you want to take that up or not.
Is that the only thing you have?
That's it, Judge.
Well, we can try to do that then, just so you aren't hanging around for for another
Thank
hour
you,
and a half,
Judge.
or however long this is going to take. Who is it?
I didn't mean to interrupt. I got Edmondson on too. It's Melissa York.
Yes, Your Honor.
All right.
Any objection?
Might be under house. Yeah.
He's present here in the office, Judge.
All right.
You need to come in here so you can see.
Yeah, get her where we.
Are you going to open on that one as well?
There she is, Judge.
All right. Mr. Bell, Miss House's indictment. I don't know if you have seen a copy of it, but it is a direct indictment charging possession of a controlled. You have seen it?
Yeah, we would acknowledge receiving the indictment and acknowledge Ms. House York being the individual named in the indictment, waive formal reading, enter a plea of not guilty, and ask to reserve the right to file any and all motions pertaining to the case, Judge.
All right. Plea of not guilty. We'll set a pretrial conference for, well, the way things are going, let me get it out to about a couple, like May 17th. All right, that's 2 months.
May 17th?
Yeah.
Yes, sir.
He has a no bond out of Barron County.
Is she free to go, Judge?
Yes. Ms. House, just staying, you're out on bond. remember your bond conditions, continue to follow them, stay in contact with your attorney, all right?
Yes, sir.
1 o'clock on May 17th. Thank you.
Thank you, Your Honor.
Thank you, Judge.
All right.
See you all.
All right. All right. Alicia Cheveria.
Judge, that's my case set for an arraignment. I also filed a motion to revoke bond that needs to be set for a hearing.
Yes, ma'am. Ms. Cheveria, am I going to need to appoint an attorney for you?
Yes, sir.
Okay. Let's have, we'll appoint somebody from the DPA, whoever's turn it is. I don't know who. Who will it be?
Josh.
Josh, you on here?
I'm on here.
All right. Do you wish to have a formal arraignment, reading of rights and charges, or do you waive that?
Judge, we waive that, enter plea not guilty, request pretrial conference and discovery.
All right. Let's set this motion. The Commonwealth has a motion to revoke bond. The issue, as I see it, is that I believe that there have been a couple of different issues, and at least one of them, it was when the jail was just releasing everybody, whether we had a bond, had a warrant on their bond or not. So, and then this last time, you know, she picked up a new felony charge. So that led me to ask them not to release her till we could get to the bottom of what's going on. This case is a possession. The new felony charge, I think, is a possession. What I'm going to throw out there, unless somebody talks me out of it, is that I will appoint counsel, put her on here for a plea of not guilty. Set the Commonwealth's motion for next week, which is we can do it on that Tuesday docket. I mean, we're gonna be here till 7 o'clock anyway again, so we might as well add one more. You know, you all can talk about theoretically this case, and you know, I don't know how much there is to know about the other case, but you know, these seem like they could be fairly work outable if we could just kind of keep new charges from accumulating. So I'm going to I had put a hold on this case. I'm going to keep her in custody till we have that hearing, which will be a week from tomorrow.
Okay.
We're going to call it a pretrial also, just so that I don't leave that hanging, but revocation hearing, that is March 23rd, 1:30. All right, Mr. Spears, we'll see you then. Ms. Chevery, we'll see you then. Angela Cross.
My motion, Judge, we just need a hearing date.
Yep. This is on for a motion to revoke probation. I believe back when the plea, at least in the 19 case, was entered, Ms. Cross had, I want to say maybe Tyler was representing her, but I will make sure that we have reappointed counsel for these proceedings, and we shall schedule those for the 23rd, which is a week from tomorrow at 1:30.
That'll be me, Judge.
All right. So Ms. Gardner and Mr. Berry will go March 23rd, 1:30. Okay?
All right.
All right. Thank you. Jonathan Todd Dean. Mr. Barry, you may recall, we started with his hearing, or we took some evidence last week. Then we were going to try to see about what kind of treatment options there might be out there available for Mr. Dean. Put him on today.
Bethany, are you on here somewhere? Bethany?
There she is. She's just on mute.
Okay, I don't see her on mine.
Yep, she's on there.
Okay.
You'll just have to trust us.
Yeah.
I'm here.
Okay. Can you address this, Bethany?
Yeah, I went and assessed him last week. He has been accepted into Kentucky Christian Recovery. And I actually spoke to him earlier, and we had talked about going to Hope House for a long-term program, which we both feel is a better fit for him. I went back to speak to him at the jail on Friday, and it was under lockdown, so I wasn't able to get the application filled out, but I have already spoken to the director about him. So he has a couple options for long-term treatment. If you were to order it.
Okay. Well, I think the conversation, or at least the hearing that we had, certainly was made it fairly clear that Mr. Dean is going to need to go to a treatment facility, a residential treatment facility, if he doesn't get his probation revoked. And I'm pretty sure that I committed to him that I'd be willing to give that a try as long as we could find a place that he could get to. I don't think this was something that there was necessarily an agreement about, but I don't know if the Commonwealth wants to say anything on the record, but I can't recall whether this was part of an agreement or whether I just said I was going to do it.
Your Honor, we had a hearing. The Commonwealth recommended revocation in this case, just because I think Mr. Dean had been in treatment before, and we thought that, get treatment in custody would be the better option. But at this point, I think the court has indicated that it was going to do it. The two options that Bethany stated, the Commonwealth doesn't have any objection to those. So.
Mr. Dean, do you have a preference, or do we just need to go first available? Mr. Dean?
Yes.
Do you have a preference as to those two places, or were you just wanting to take the first available one?
Yeah, we lost connection here. So it froze up for like the last.
Well, there was Kentucky Christian Recovery, and then there was Hope House. And I think Bethany said that you were eligible to go to either one of those. And I understood her to say that maybe the Hope House was the better option, but I don't want to be putting words in your mouth. So did you want to go to the first available one, or did you prefer the Hope House?
I think the Hope House would be better for me long term. It's
all right.
Yeah.
Your Honor, I guess just for my own education or clarification, Bethany, why would you recommend the Hope House over the Kentucky Christian Recovery in this situation?
So the Kentucky Christian Recovery is anywhere from 3 to 6 months. Hope House is an entire year. And after the first 6 months, he can actually start find employment and start working. So people who are more successful in Hope House, they come out of it with more of a stable environment. For him, it's been something that he's found difficult after going to rehab, which is why I leaned more towards Hope House than Kentucky Christian Recovery.
Okay.
Yeah. Mr. Dean, I'm going to determine that Hope House is a good place to go. I mean, I think that seems to be the consensus among you and Ms. Steenbergen and now me. So Bethany, I guess the normal thing that we do is just wait until you get me a bed letter, and then we'll make a decision about, how he's going to get out. And I don't know if we need to talk about transport or if you all can handle that on your end.
They come and get him.
Is that a come and get place? I couldn't remember. Okay.
Yeah, due to COVID, they're coming to get him from the jail.
All right. So all I'll need is just notification of when they plan to do that so that I can put it in an order. Okay.
I will do.
All right, Mr. Dean, that's what we'll do. And you're going to be ordered to enter and complete that program and any other aftercare or other requirements that are part of the program. And that'll be a condition of your probation staying intact, okay?
Okay, all right, thank you.
All right, good luck, sir.
All right, thanks.
Thank you. All right, we got the Brittany Decker final sentencing, I think.
Yep.
Mr. Spears, you with us?
Yes. Yes.
All right. I'm sorry. When I get this many people on, I can't see everybody's picture at once, so I don't know if they're, all right. So has everybody had the opportunity to see the pre-sentence investigation report?
I have, Your Honor, and I believe Ms. Decker has as well.
Okay. Are there corrections or other things to address in that report?
Not that I'm aware of. Brittany, is there any? Okay.
All right. Any motions?
Judge, I would move at this time that this sentence be probated for a period determined by the court and by the conditions set by the court. I know Ms. Decker was on pretrial diversion. That's the reason we're here today. But I feel another chance at some sort of a probation type situation might be more beneficial to her in the long run on this charge. So I'd ask that this be probated.
Okay.
Judge, I don't think it should be probated. I think Ms. Decker had multiple chances to be successful on diversion, and she just didn't get it done. I'd also like to point out that, and it's in the PSI, that she had a F case, a burglary case that was amended down by the county attorney to a misdemeanor. So she got a break there as well. And I think she's got other felony cases in other counties. So I think she's had multiple chances, Judge, and I think she needs to be sentenced to the years that she agreed to in the diversion agreement.
Is there, Mr. Spears, do you know, does she have other motions pending or anything in any other county?
Not that I was aware of. There's a possibility, but I was not aware of any.
Well, can I tell you, I'm going to be frank as I can with everybody. There is absolutely no way that I think any reasonable person could look at all of this that's happened in this case and in other related cases and make any kind of argument that Ms. Decker Ms. Decker hasn't had plenty of opportunities to show that she is willing to comply with the rules. I mean, she's kind of flouted the rules at every opportunity in this case. She does have cases pending as far as I can tell, or at least maybe on probation or whatever over in Edmonson County. But I mean, here's the deal. She owes almost $1,000 in restitution in this case. There's a victim out there that ought to be getting paid. If I revoke her, or if I sentence her to serve this, she's got 227 days credit on a 2-year sentence, which basically means that she's not going to be in there very long. On the other hand, if I put her on probation, I believe I could better monitor her restitution payments and also any kind of ongoing compliance issues that we might have. So I guess this is one of those where up is down and down is up, because, probably she ought to be asking me to just sentence her so she can stay in jail for another week and then get out. And the Commonwealth probably ought to be asking me to probate her so that we can keep an eye on her. That's what I'm going to do, is probate her sentence so that I can monitor this restitution and try to get this victim paid this $1,000, $938 or whatever it is, $970. All right. Ms. Decker, the important thing for you to understand there is, if I let you out, it's because primarily I want this money that you're supposed to pay to get paid. And if you don't pay it, that's going to remove most of the reasons that I think you ought to be out, and you'll get your probation revoked and go back to jail. You understand that?
Yes, sir. It'll be paid first thing.
Well, that would be really nice, if it happened that way. So I've got a probation officer on here, and I'm going to, have him address you, Ms. Decker, and tell you what to do. But I want to make it clear that you understand that I'm not granting your request for probation because I don't think you've had enough chances to show that you're willing to follow the rules. You've had plenty enough chances to show that you're willing to follow the rules. So what I'm telling you is I'm going to give you the opportunity to prove that you've grown up a little bit. It isn't because I don't think you've had that opportunity yet. It's because, you know, you've got obligations to other people out here and you need to be taking care of them too.
Hey, Judge,
Yes.
since you just said that it'll get paid first thing, why don't we set a show cause date in the next couple of weeks?
Yeah, I'm going to set one. I mean, I don't know that I can make her pay it all that up at once.
That's
but-
what she said.
I just got my stimulus check. I can pay it as soon as I get out.
All right. Seth, tell her what you need to tell her.
All right. Thank you, Judge. Ms. Decker, I need you to contact Probation and Parole Office upon your release. You need to call Robin Frazier first at 270-282-3128. And if you can't get a hold of them, just report to the office by 9 a.m. Tomorrow morning.
Yes, sir.
If you're released today.
All right.
That's it.
All right. So Seth, this is 18 CR 135. It is the sentence is a 2-year sentence. Fine and costs waived. That 2 years is probated for a period of 3 years on condition that she complies with probation and parole, and that she pays that restitution. Since Ms. Decker, you tell me that you're going to pay that with your stimulus money, and that's obviously enough to pay it. I'm going to put this show cause on for April the 19th. That's 4 weeks from now. All right. And at 10 o'clock, you need to be in contact with your probation officer before then. And if you don't have this money paid, then you need to be in contact with your attorney so you can figure out how to get on this Zoom hearing, okay?
Yes, sir.
Because you're not going to be in jail, heaven forbid, unless something else happens between now and then. So I expect when you get out, you're going to take care of this, okay?
Absolutely. Thank you.
All right. Do you have any questions?
No, sir.
All right. Thank you.
Thank you.
Lorenzo Martin.
Judge, I think we have an agreement in this. Xanda, I guess, correct me if I'm wrong.
Yeah, I believe we have an agreement. I will, just so the court knows, Mr. Martin was under the impression that his family had hired Bobby Richardson. I think Mr. Gardner reached out to Mr. Richardson, confirmed that he has not been retained as of yet. I will state for the court that Bethany has had an opportunity to assess Mr. Martin, and she's located a rehab with Park Place. They have a bed open for him available on March 24th. And it's my understanding that the Commonwealth is agreeable to him going to that rehab on March 24th. Obviously, Mr. Martin would need to stay in custody until he leaves for that rehab, but I think that Mr. Martin was okay and on board going to rehab.
That is the agreement. Mr. Richardson did reach out to me on the bond issue. I don't think the judge is aware of that. But he was not retained by Mr. Martin's family. I don't think he's paid the retainer. So at this point, he is not representing Mr. Martin.
She said she paid it for me though.
Well, I texted Mr. Richardson today. He said he hadn't received it.
I was going to say, when we set the hearing, we sent, I think, either by email or otherwise, we communicated with him to tell him about the hearing, and he said that he hadn't been retained, and if he was, he would come to the hearing, and if he hadn't been, he wouldn't. So that's all I got. But now, I mean, if they want to go talk to him after this, or you know, whatever, that's up.
I get out, then I can go pay him myself. I'm saying, if my cousin didn't pay him, means she took my money. I got to do something about that too. You know what I'm saying?
Well, I understand that, but I mean, right now, what it sounds like is your attorney thinks you have an agreement to go to rehab. Do you have an agreement to go to rehab or not?
Yes, I guess so. I guess so, sir.
Yes?
Yes, sir.
I mean, it has to be,
Yes, sir.
I mean, that's not something that I'm forcing down your throat.
No,
That's
I
just-
know, I'm just saying.
Yeah,
Come
yeah.
back,
All right. All right. So is that going to be a short term? The reason I'm asking, he already has a pretrial conference set in May, and I wonder if I need to change that.
It's Park Place. I think Park Place is short term. Is that correct, Bethany?
Yeah, it's only a 28-day program.
All right. So he'll be out by May 3rd,
Okay.
which is when his hearing date is. And what needs to happen, two things, Mr. Martin, when you get out, you need to get in touch with your attorney immediately, okay? So that you all can discuss what's
sir.
happening in the case before May the 3rd, because there won't be but a couple of weeks or, 10 days or something in there. And the second thing is,
sir.
you'll still, until I see you again, you're still obligated to report to Julie for pretrial drug testing, at
Yes,
least
sir.
until I talk to you again, okay? So when you get out, you need to make contact
Yes,
with
sir.
her and let her know you're back in the saddle, okay?
Yes, sir.
All right.
Yes, sir.
Does anybody have any questions?
No questions. I just want to clarify, Mr. Martin, if you do not retain Mr. Richardson when you get out, be sure that you call me on that card I gave you, okay?
Yes, ma'am. Yes, ma'am, I will.
Yeah, are you gonna send me something, Bethany, on that bed date so that I can do an order with the specifics in it?
Yes, I'll forward it to Chrissy already.
Super, thank you. That's March, it was March 24th, but
Okay.
just any kind of details I would need. All right, thank you.
All right.
That pretrial will stay on, okay? All right, Mr. Martin, thank you.
Thank you.
Joseph Jewell. All right, this was on for a pretrial conference back in early October, middle of October. Mr. Jewell was not present, so a warrant went out, and that brings us here today. He just got arrested on this warrant. What is it? 4 or 5 days ago. So what I believe we need to do is figure out who the officer is going to be, or the attorney is going to be, set a pretrial conference, and see what we can come up with. Mr. Barry, do you all know who's going to have this one?
I don't off the top of my head, Judge.
It's Josh's case.
Okay, I had not written it down, I had just written DPA when I appointed you. I didn't write down who it was going to be.
Okay.
All right.
My notes indicate that we've sent discovery and an offer. If Josh doesn't have either one of those, please contact us.
All right.
All right, Mr. Spears. So here's the situation. We're going to put Mr. Jewell's pretrial on for, I mean, you tell me, but it probably needs to be at least enough time for you all to talk. I mean, here's what happened. He got picked up in September for a bond violation. I let him back out and gave him a court date like 3 or 4 weeks away. He didn't show up for that, and he's been in the wind ever since. So, I mean, he's going to stay in custody till we have this pretrial.
All right, can we go at 2 weeks of the 29th, Judge?
Yes.
That should give me enough time to go talk to him.
All right, March 29th at 1 o'clock.
All right.
Thank you.
That it?
That is, yes, sir. Thanks. Zach Johnson. This is on for a motion by the Commonwealth to void pretrial diversion. The motion is based upon a report from probation and parole of an adulterated drug screen. Mr. Gardner, are you asking for there to be a hearing on this?
I am, Your Honor.
All right. We'll make sure, I need to make sure there's a DPA attorney assigned to this, and we'll put it on for Tuesday, okay?
Okay, Judge.
That is 3/23 at 1:30 for the Commonwealth's motion, okay?
And Bethany, if you're listening, if you want to assess him and, you know, send me a treatment option, I'll be willing to listen to that.
Okay, I will write him down. Zach Johnson.
Yes, ma'am. All right, thank you.
Thank you.
James Brandon Keaton. All right, this is an arraignment. Mr. Keaton, do I need to appoint an attorney for you, or do you have an attorney?
I need you to appoint one for me, sir.
All right. We will appoint someone from the public defender's office here in town to represent you. I don't believe there's a co-defendant in this case, so there shouldn't be any conflict related issues. This is a relatively old underlying charge. There's been a summons out the whole time and it just had never gotten served. I guess Mr. Keaton's gotten picked up on something else because I was just trying to summons him, so.
Yeah, Your Honor, the jail website indicates he's got a parole violation.
Okay. All right. Who gonna handle this from the DPA?
I'll do it, Judge.
All right, Mr. Berry, do you wish to have a formal arraignment?
No, we'd waive formal arraignment, enter not guilty pleas to all charges.
Okay. Let's get Mr. Keaton on for a pretrial. Why don't we do, Mr. Keaton, just a couple of questions to orient myself. Do you have some kind of administrative proceeding coming up with the parole board or anything?
Not that I know of.
Not that you know of? All right.
I'm actually his officer, if I may. He's going to be served with some paperwork tomorrow, so I can let him know, but he's not scheduled for any hearing at the moment.
All right. Would it be safe, Seth, if I put his hearing off about a month, would it be safe that he won't do anything before then, or will he do something before then?
No, that'd be safe, Judge.
All right. Let's put a pretrial on Mr. Berry for April the 19th.
Okay.
At 1 o'clock.
Seth, this is John. Can you send me the information about the parole violation?
Yeah, that's not a problem.
All right, Mr. Keaton. The charges, Greg, are possession, controlled substance, first degree, second offense, and tampering. Okay?
Okay.
All right. All right, Mr. Keaton, we'll see you then.
All right.
That's April 19th at 1 o'clock. Courtney Pruitt.
That's my mission, Judge. We just need a hearing date.
Yes, ma'am. We're going to do Tuesday, the 23rd at 1:30.
Greg, will you be handling this one still?
Yes. Yeah.
All right, so 3/23 at 1:30, DPA will be reappointed. Mr. Berry will take it. We'll see you then. Cody Spencer.
Bethany, you met with Cody, didn't you?
Did.
Okay.
I'm all ears metaphorically.
Go ahead, Bethany.
So I also spoke with the social service clinician about maybe trying to refer him to their SHARE program, which has a significant mental health diagnoses track. The problem is that I can't find or know of any significant mental health diagnoses he's ever had before. But he definitely displays a lot of characteristics of someone who has a significant mental health disorder, with some paranoia, some delusions of grandeur, delusional
What if
thinking.
what if I were to get KCPC involved in doing ask them to do a competency assessment?
Your Honor, I would request that. I think that would be
Well, first
warranted
off,
in this situation.
yeah, first off, that's going to get us over the diagnosis hump, if nothing else. And then, with the diagnosis, we can figure out what our options are. Right?
Correct. He's more eligible for that program once he has a diagnosis. It would help.
Okay.
Hold at this point.
I mean, I think based upon the testimony that we heard prior to recessing the hearing, there was an issue with, I think Officer Bennett was the one testifying, but I don't think there was any explicit use of the word absconding, but it was failure to report and failure to respond and all that. So, I don't think that the interests of justice are offended too much if I have him evaluated in a custodial setting, which is what we would have to do for KCPC. Okay. And then I can put the matter back on for, let's say, 30-ish, 45 days, something like that. That'll be a probably best case scenario of how long it would take them to get into it. All right.
Okay, Judge. Will you just be doing the order or just do an order without a motion?
Yeah. I'll just do an order. We've got one that we do, and then I'll put him on for, why don't we call it? I guess we can do May the 3rd. That's 45 days, maybe May the 10th.
Okay.
The reason I'm shying away from May the 3rd is because I don't have any idea what the world's going to look like on May the 3rd when we're trying to get back in here and do some in-person court. And that'll be our first Monday we're doing it. And I'm just a little concerned that it's going to be hard to deal with. But May the 10th would work better. And that gives them more time to get him in and do what they need to do anyway. So May the 10th at 10 a.m. Okay, and then we'll pick it up then. All right. Thank you. Okay. Jason Taylor.
That's my motion, Judge. We just need a hearing date.
Yes, ma'am. Tuesday, the 23rd at 1:30. This case was, make sure that we know who's doing it. Yep, I didn't write it down. Mr. Berry, I can't remember who had this one from your guys. There really hadn't been much happen yet.
I've got Xanda on it.
Okay. All right, we're gonna have this set for hearing 3/23 at 1:30. Okay?
All right, I thought my date was in April. I already had a court date.
It's gonna be March 23rd now, okay?
Okay.
All right.
Hey, since I'm in here, can I get like, I pulled an ACL. Is there any way I can see a doctor? Cause I'm just killing me. I hadn't seen a doctor. I've been here a week. Is there any way they can help me out there?
Is there, I mean, I don't know what you're asking. Have you put in a request to see somebody?
Yes, a week ago. Yeah.
Has the nurse seen you?
No.
He's hurt bad.
Yeah, I've been.
Yeah, I mean, they just need to, I mean, listen, we've already had this whole conversation once and you weren't following your bond conditions. So I had a conversation with you about that and let you out. And then we're right back in the same situation we were in.
Yeah, I didn't get your phone call on my bond. I mean, when drug test.
Listen, we talked about all that. All right. I mean, I'm not going to let you out and, cross my fingers and hope you listen to me better than you did the last time, just so you can go to the doctor. They'll take care of it. They'll take care of it down there. Okay.
All right.
All right. Randy Wide.
That's also mine, Judge, and we need a hearing date.
Yeah, this case will end up being there's a motion to revoke bond, and we're gonna put this on for Tuesday as well, week from tomorrow.
That's mine, Judge.
All right, Mr. Berry. Hearing 3/23 at 1:30. Okay. All right, thank you. All right, we've got Mr. Williams next. I'm thinking, Mr. Berry, this may have been another one that after we were in the middle of doing his hearing, or after I heard the evidence in the hearing, I may have asked for there to be an assessment done on him.
You did, Judge. Bethany, did you met with Mr. Williams, didn't you?
I did. I spoke to Mr. Williams after talking to him about his history and a lot of the legal precedents that he has going on right now. He has agreed that long-term treatment would be beneficial for him. I have referred him to Hope Haven, and I did that last week, but due to the jail schedule, they're not able to assess him till the 17th. So I'm not sure if he has been accepted there or not yet.
Okay. Well, so would it behoove us to put this on for next Monday so that assessment can have time to happen?
Correct. I would know about it.
I don't want to just assume that it's going to work out. So I think it'd be smarter to put it on for a review and then hear what they have to say and then go from there.
Okay.
Okay. And I think this is another one. I don't think that there was necessarily an agreement about it. So I want the Commonwealth to also hear what comes out of that assessment. And then, if they want to put something on the record and make an argument, I'm going to give them that opportunity. Okay.
I would say though, Judge, I would like to see him go to long-term treatment. I think that's what we were a long time ago trying to get him to do. So.
Right. All right. So we're going to review it on March 22 at 10 o'clock. Okay. That's a week from today. Dante Morrison.
Judge, in my case, the motion to revoke.
Commonwealth has a motion to revoke. We're going to set this for Tuesday, 3/23 at 1:30.
All right, thank you, Your Honor.
Thank you. Sorry, I didn't give you all those last time. All right, Bonnie, do I have anyone else in custody?
That's all I've got until this afternoon.
Okay, see you in a little while.
Judge, could I ask Bonnie a question real quick about
Oh,
someone on
yes.
this afternoon's docket?
Yes.
Bonnie, Charles Perkins is on at 1 o'clock and his attorney, Stephen Poindexter, had sent him some paperwork for him to plea in his pending felony case. Do you, he was supposed to sign that. Would you be able to get that and email that to me or back to Mr. Poindexter?
Oh, well, what is your email recent?
It's rgardner@prosecutors.ky.gov.
Yeah, I'll get it right to you.
All right, thank you.
All right. Thanks, Bonnie.
You're welcome, Judge. Thanks. See you later.
See you. All right, let's see. I know I've got several other guys, maybe a gal or two on here. Does anybody want to call anything in particular?
Judge, I can just say real quick on Jacob Akers. I don't know if he's on the call somewhere or not. If not, he's set for sentencing.
Right.
I've not talked with him about it. I've not given him the PSI. We have the PSI, just haven't talked with him about it.
I'm not, yeah, Jacob Akers.
Pretty sure he was told to be on here.
Oh, I'm 100% sure he was told to be on it. I agree. Because he was on this Zoom call the last time and he was able to do it. And the only reason we didn't do his hearing last week was so that he could get his PSI. Yeah, I'm a little reluctant. I mean, you know, Mr. Berry, best case scenario, I could pass it a week and let you try to get in touch with him, but I'm not sure what the likelihood of that being successful is.
I don't know, Judge. If we could, just one more week and let me try it. I'll try.
But I mean, he was definitely informed as close to in person as you can be to be here. I'll be willing to try one more time.
Okay, thank you, Judge.
Just to keep from there to, you know, March 22 at 10 o'clock. But I mean, listen, you know, if we get there and he's been in touch with you, but he hadn't read his PSI, and we, you know, I mean, we're going to have to keep going through all this again. I would expect the Commonwealth to ask me for some reparations, and I might be willing to agree with him because you know, he's making this hard on us, harder than it ought to be. Okay.
Yeah.
All right. Let's see. Who else do I got on here? I see Mr. Miller there. Isn't that who I'm seeing? Tommy Miller?
Yes, sir. Yes,
Yeah.
sir.
I think your attorney has filed a motion in your case. I don't know if it's I don't know when our pretrial's set.
Yes, she said she filed a motion to get the ankle bracelet removed.
Yeah, hold on a sec, okay?
Okay.
Mr. Berry, Jacob Akers has apparently just called the office. He's on hold. I'm gonna tell him to get in touch with your office or you tell me who to have him call because I want him to get his PSI. I'll leave it on next Monday because he hadn't seen it anyway. So we wouldn't be able to do anything about it right now anyhow. But who do I need to have him call so that we can make this thing happen on Monday?
Yeah, just call the office number that we've got, 833-385-6055.
Okay. And tell him he needs to, yeah, he was supposed to do all this before today, so be sure to pass that along, please. All right, thank you. All right, let's see. Ms. Myers, Mr. Miller was stating his case. Do you have anything you want to add?
Hey, I apologize, Your Honor. Mr. Miller's case has just recently been transferred to me. And after speaking to Mr. Miller, he says that he's been on an ankle monitor for almost a year, if not over that. He does have current employment. He's actually working at Yami now. I think he's made all of his court dates and he's complied with all of his conditions of release thus far. He's wanting to request that the ankle monitor be released. I think actually the people at U-Turn brought it up to him, Your Honor, and mentioned to him that he'd had that ankle monitor on quite some time. I looked through CourtNet and I couldn't see where the ankle monitor was actually required by the court, but it may be that I'm just missing an order or overlooked it. But I was just filing this motion to request that the court allow him to get that ankle monitor removed. His next pre-trial conference isn't until April 12th, and I'm positive he's going to appear for court that date. But because of his new employment, and he's had a couple of issues where he's just kind of fallen and tripped with the ankle monitor too, but he's been on it for quite some time. So we were just going to ask the court for a little relief to get that ankle monitor removed and keep him on all the rest of his bond conditions.
His ankle monitor, the reason you couldn't see anything was because his ankle monitor was put on him when he got out in district court. And, you know, when he got indicted, I just allowed him to stay out on the same bond, but it had those conditions on it. And, you know, obviously then kind of the wheels got wobbly on the rest of the world. And we hadn't really done much in his case for a little while because of the circumstances that have been going on worldwide, you know, but yeah. So, is this Mr. Richardson? Is this yours?
It is, Judge.
All right. Do you want to address that request?
Yes, Judge. We've talked to the victim's family, and they're very concerned about this. And I do believe that there was a preliminary hearing done on this. I do believe it's part of the record, Judge. But you know, we have very strong evidence in this case. It's not just a simple accusation. There's also an admission of guilt. We are very concerned. These are very serious charges, and we do believe that. Frankly, I think Mr. Miller, you know, should be grateful for the bond he got because I do believe he is a danger to the public. And I think that his ankle monitor being on there, you know, if he hasn't done anything while he's on it, then good, it's working. I'm not too concerned about him getting time because we're already asking for substantial time in this case. And I intend to continue to seek that in this case. And also, we've also been in contact with the victim's family and they've been involved in this. I'd ask the court, we would have tried this case back in January if it wasn't for the COVID restrictions. But I'd ask the court to keep his ankle monitor on for the time being.
Yeah. You know, the problem is he has been on this ankle monitor since roughly about 3 weeks shy of it being 2 years. He didn't get indicted right away. You know, I mean, he got out in district court in April of 2019 and, you know, he was on it throughout the period of time that he was on, that it was pending in front of the grand jury. And then, you know, basically, like I said, I think it's kind of bounced around from one attorney to another, which of course is not Ms. Meyer's fault. She just now got here. But, you know, I understand that is a significant monetary undertaking for somebody, and I appreciate that. The flip side is this case is a little bit, you know, different because it just looking at the nature of the charges, this isn't like I mean, you know, it's something where probably all the people kind of know each other and it makes it hard for folks to, you know, you don't have a victim in one group and a alleged violator in the other group. You know, you've got everybody kind of in the same group of people that are, you know, that are together. And that's troublesome. And I understand why the Commonwealth is having a problem with it. I do think that there has to be some concession made to the alleged victim in the case and whether or not that person feels like they are at risk. I would like to think that Mr. Miller, I mean, it might go without saying, but I guess I better say it just so it didn't, that if he did get the ankle monitor off, and then there was a problem with contacting this person or whatever, then you're probably not going to be looking at an ankle monitor the next time. You would probably, if the proof was there and showed that there had been a violation and that you've been following all the rules while you had the monitor on, and then all of a sudden you take it off and you break them, the odds are pretty good that the Commonwealth would be asking you to just go back to jail and stay there. And, they might find a receptive ear, you know what I mean?
Mhm.
Because the beauty of this monitoring, I understand it's costing you a lot of money, and that's really the big negative. But the beauty of it is that, as Mr. Richardson pointed out, it's apparently done its job, because I haven't heard any violations of it. And you've been in front of this court for a year and a half almost. You've been on the monitor for almost 2 years, but you've been in front of this court since like September, October of 2019. So, there is that if it ain't broke, don't fix it kind of theory, that it's working and maybe we ought to leave it on. But again, I understand that's a lot of money too. And I wouldn't even be able to begin to calculate how much that's been over the course of almost 2 years. So that's kind of the main thing. I know he's also had some health issues. I remember Julie talking to me one time about he had to go to the hospital and we had to take the monitor off because he had to go to the hospital and get some testing and some stuff like that done. And I think he was compliant with reporting back to her and getting it put back on. I guess at the end of the day, Mr. Miller, I err on the side of trying not to make it any more burdensome on you than it has to be. And it's been pretty burdensome up to now. And I think I'm obligated to try to look at less restrictive alternatives if I can. And all I can do is tell you that, especially if people are unhappy that the monitor gets taken off, you better be on your best behavior as far as whether you're making any contacts or even indirect contacts with anybody that's involved as a witness against you or a potential alleged victim against you, because they're going to be running right back as they should and reporting that, and then we'll be having a different conversation next time.
Mhm.
Okay.
I go to work at Yami in Park City. I work 2:30 to 10:30, and I come home.
Okay. Well, so I think because of the passage of time, it is a well-taken motion to request this, and I'm going to grant the motion with those admonitions that I gave you. All of your conditions are staying the same in terms of having any, obviously not having any contact or communication directly or indirectly with any witnesses or family members of the witnesses that, that might be seen to be trying to put some pressure on anybody. Okay. I know you're related to the same people, so I can't just say you can't talk to anybody in your family, but the victim or immediate family of, or alleged victim, immediate family of the alleged victim, no attempt to influence any testimony or anything like that. Okay.
Okay.
All right. Would it do us any good to talk about moving that pretrial, or should we leave it on?
Judge, whatever the pretrial, I don't want to move it out because, we've had discovery. I know Xander just got on this, but we've had discovery and offer out for a long while now. And Mr. Miller, I'm sure, has had an opportunity to look at everything. So I know Xander needs to look at it, but he knows what's going on.
I just wanted to, I was just trying to maybe make sure that Ms. Myers had the chance to dig into it a little bit. I didn't want to have, I don't have any question that Mr. Miller's had time to consider what he wants to do, but he may have not had time to talk to her.
Well, and obviously, Your Honor, I have to, sometimes my job requires more than just looking at discovery. I have to actually weigh other actions that I might need to take. I'm not going to be prepared, I don't think, to set a trial date on April 12th, but I am looking through everything at this point, and we're kind of going to decide our litigation strategy going forward prior to April 12th.
Okay, well, let's leave it. We'll just leave it on, and then we'll talk about whatever there is that needs to be talked about when we get there. Okay.
Thank you, Your Honor.
All right. Mr. Miller, make sure you're staying in contact with your attorney, and your next court date is April 12th at 1 o'clock, and it'll be done, Zoom like this, okay?
Okay.
All right.
So am I keeping the bracelet on or?
No, I'm going to grant your request to get that off. We'll send something to Julie. You just need to get in touch with her.
Okay.
But all your other conditions are on there. And like I said, you need to be, on your toes about avoiding
No
any kind of contact or appearance of impropriety, okay?
No problem.
All right. Thank you.
Thank you.
All right, let's see who else we got. I got Mr. Kraft on here.
Yes, sir.
Judge, he has a pretrial sentence review, and I'm showing he still owes some restitution on this.
Looks like, yeah, it looks like the thing that would get in the way of this pretrial suspension review would be the $484 that you owe.
Yes, sir. I tried paying that online, and when I do, it says it's not payable.
It says what now?
This case is not payable or something like that.
Huh? Why would that be, you reckon?
When was this? Was it today?
Yeah, I tried this morning.
Oh, could it be? Could it not let you pay it if it's happens to be on the docket or something? Like they don't want you to pay it on the day of your court date because to avoid confusions. Yeah. Why don't I mean, do you, but for that, are you saying you think you could pay this whole lick?
No, probably not the whole lick, no.
Well, how long would you need?
Maybe a couple more months or something.
Well, I mean, it's possible that you just couldn't pay it on your court date because, that would cause some confusion. They might have put something in. It's a new system. They might have put something in this. We're all kind of figuring out how it works. So they might have put something in that to not let you pay on your court date so that there wouldn't be any confusion about whether you owed any money or whatever. But if I give you a court date for 2 months away, then you ought to be able to get that paid. And you can always call and pay over the phone, but the online payable is easier, but you can always call and try to pay over the phone. Okay.
Okay.
All right. Do you need a number or do you know it?
No, I need a number, sir.
All right. 270.
All right.
651.
651.
9830.
9830.
Yeah.
Right.
And let's push it out to May the 24th, okay?
Judge,
Yes.
I mean, I don't care to set it a couple of months out for him to pay the whole amount, but if he's saying he tried to make a payment, can we set another date in a week or two for him to make a partial payment? I mean, maybe he could tell us right now what he's able to pay.
I could pay, at least right at half of it or something today.
Well, I mean, if you don't get it all paid by May, you've already told me you can pay it in 2 months. So if you don't get it all paid by May 24th, then they're going to file a motion to revoke your pretrial diversion.
Yes, sir.
Okay. Because it's been going on for 3 years. I mean, I understand the point, which is that you've had the opportunity, it should have been paid by now. And I agree. But, if you tell me you can pay it in 2 months, we're going to make it put up or shut up day. Okay.
Yes, sir.
All right. May 24th at 10 o'clock.
All right. Thank you.
All right. That's supposed to say 10 o'clock. I better mark it out and write it again because it looks like I wrote it with my foot. Let's see. I got somebody else on here, but his phone's it says Phoenix 4, so I can't tell who it is.
I believe that's Albert Page, Judge.
Oh, Mr. Page. Okay,
Judge, we'll probably have to push his back to next week because I haven't been able to get an email address for him to get his PSI to him. But I think now that he's on here, I can get it to him.
all right, ask away.
All right, Mr. Page, what's your email address?
It's Albert Page 69 @gmail.com.
All right. Be looking for an email from me in the next 24 hours with your pre-sentence investigation and just review it and be back on next week at this time, okay?
Okay.
Yeah. 3/22 at 10 o'clock.
All righty.
All right.
Thank y'all. Have a good one.
You too.
Thank you.
Thank you.
Mr. Sneed. Is Mr. Sneed on for sentencing also?
Yes, and he has confirmed he's reviewed his PSI with me.
All right. All I got now is I can't hear him. There we go. Oh.
Hear me, Your Honor.
There he is.
Yes, sir. Good morning. How are you?
Mr. Sneed, you're on for a final sentencing and your attorney says that he has had the opportunity to send you your pre-sentence investigation report, right?
That's correct.
Did you review that?
Yes, I did.
Was there anything in there that you want to take issue with, or do you think it's accurate?
It's accurate, Your Honor.
All right. Is there any reason not to proceed with sentencing on Mr. Sneed today, known to either council or the Commonwealth?
Not that I'm aware of, Your Honor.
All right.
Yeah,
Are there,
there's not, but there is I think he owes an additional day for a DUI. I think he has one day credit.
okay. Let's take a look and see what. Yeah, this was back in the, they just barely arrested people back in August. So when you got in, you went right back out.
No, sir, I did not. I stayed quite a while there, but I don't know what the minimum is to serve several hours.
Yeah, well, you got to do 2 days, and it looks like you got arrested like just after, I mean, like at 1 o'clock in the morning.
Yes, that's correct.
So then, I mean, by the time you got out, it was still the same calendar day, which is what.
Oh, okay. Yes, sir. That's correct.
Yeah, that's what they're referring. I mean, I can't tell a time on it. Yeah, you might have been there a long time, but
seemed like forever.
I guess you had to be there long enough to, yeah, get all your paperwork. Yeah, so on a DUI, on a first offense, the sentence is 30 days with 28 suspended, and you get credit for 1 day. So that means there's like a day in jail that has to be done. I'm not real sure how we're going to do that because, I mean, I think we could, obviously they're taking people into the jail, so we could figure it out, but I don't know what kind of, if there's anything special we need to.
Yeah, I don't care, Judge, if home incarceration is an option or not. Okay.
I mean, I guess we could do home incarceration. I mean, it would cost you a little money, but I mean, you basically do 3 days on home incarceration, which would probably be pretty easy on the weekend or something.
Whatever the court deems, Your Honor. That sounds fine.
I mean, would you rather do that than go spend a night in jail?
Of course, sir.
Yeah. I'm not being a smart aleck. I'm just asking. I mean, you might
No,
say
yes,
I
sir.
don't pay for it. Yeah.
Yeah, that'd be fine. Thank you.
Yeah. We can do it. You know, I'll talk to you about that when we get done. Okay. Because we can make that work. All right. I'm going to, Mr. Sneed, I'm going to accept the agreement between you and the Commonwealth and sentence you to 2 years total. That 2 years will be suspended except for the one day that we're going to talk about in just a minute for a period of 2 years, supervised by probation and parole. You'll be required to do the DUI treatment that we've already discussed at the time of your plea, and the DUI counseling. You have a service fee, which doesn't get waived. That's $425. That will need to be paid within 6 months. Okay. So, you can pay it a little bit by a little bit, or you can pay it all at once, or and you may have heard us talking before, you can pay online and you can call in and pay it, however you want to go about doing it. By the time 6 months gets here, it'll be open and you'll be able to come in and pay it in person if you want to.
Yes,
All
sir.
right. The big kicker, because I can tell you're in a car, is that on a DUI, you're going to get your driver's license revoked as well.
I understand.
Okay. So
Yeah, I've got a driver with me today. So,
all right. All right. Well, I mean, yeah, you can get wherever you're going, but because all the paperwork won't be done, but within a day or two, your license will be suspended, and you need to, by law, what you need to do is mail your driver's license in so that you're not carrying it around, because you're not supposed to carry a suspended driver's license around. Okay.
yes, sir.
All right. The other part is on that one day, what we'll do is turn that into 3 days of home incarceration, if you want to do that. And I don't imagine that's a question. Where do you reside?
Well, I live in Adair County in Columbia, but I work out of town all the time, Your Honor. Right today I'm in Nashville.
Yeah.
That's where my company's based, in Nashville. So generally I'm pretty much in Nashville or Northern Alabama all the time for employment.
Are you home on weekends and things?
About once a month. I get home. We don't get a lot of time home. No, sir, we don't. But I'll make a point to comply.
Well, what I think I can do is give you a phone number to the people that do this ankle monitor. You can call them, and what you can do is, if you can make it home like on a Friday, even if it's late in the day, as long as it's not nighttime, you can get the ankle monitor on Friday, and they can keep it on, until, I don't know. I'll let them work it out with you, but Monday morning or something like that, and they could come in and work. You all could get it worked out. Okay.
Yes, sir. Yes, sir. I'll work it out.
All right. The number is 270.
Okay.
629.
Okay.
2130.
2130. Got it?
Yes, sir. And we're going to send them something and tell them to be on the lookout for a call from you. I'd like for you to call them by the end of the day tomorrow, because that way we won't have to wait around and know that you've called them.
Isn't Easter coming up pretty quick?
Yes.
I'll be home that weekend.
Yeah, sure. That weekend will be that week. I think Easter's the April 4th.
Will that be soon enough for the court?
Sure.
Okay.
I'm pretty sure. Isn't that right? Am I wrong about that? April 4th? All these ladies are nodding their head yes. So I think they'd be more likely to know than me, but I think that's when it is. All right. So and then your 300 or your 425, your service fee, give you 6 months. I'm gonna waive you other fines and your costs, just because you're gonna be paying for this monitor and everything else.
Thank you.
We got a probation officer on here. He's gonna talk with you about how you discharge your obligation to report to probation and parole. Okay.
Yes, sir.
All right, Seth.
Thank you, Judge. Mr. Sneed, you will need to, will you be in Glasgow tomorrow?
If I need to be, I will be. If I have to, I'll make arrangements.
Yes. If you could report to our office, probation and parole here in Glasgow, in the morning. Do you need the address?
Please.
It is 100B Reynolds Road, Glasgow, Kentucky. If something happens and you cannot make it there, I'll give you a phone number to call. It's 270-791-4940. That's That's my state cell phone number. So if anything difficult's that with work or whatever, give me a
I'll
call.
come home tonight and, what time? 8 a.m. All right, 9? What time you get going?
9 a.m. will be fine.
Okay, I'll be there at 9 a.m.
All right. Sounds good. Thank you, sir.
Thank you.
Mr. Sneed, any other questions?
None right now. Thank you, Your Honor.
All right. Good luck. Take care of yourself.
Thank you. Have a good day.
All right.
Bye-bye.
I've got multiple pretrial diversion reviews that we've got on here. I think we can probably take care of. Y'all just tell me if you got any issues. There's Timothy Allier,
He's okay, Judge.
Robert Browning,
He's okay.
Michael Cummins.
Judge, I've got on here that he's had an active warrant since 2017.
Okay. Yes, you are correct. So, I'll just stick that out a little ways and not dismiss it. Micah Phillips.
She's okay, Judge.
That's okay to dismiss?
Yes.
Okay. And now this Rufus Huff, that's one that you've got a motion pending, don't you?
Yes.
Yeah. So did he ever get an attorney? He told us he was getting an attorney. He didn't want the DPA to represent him at the last time we talked about your motion, and then everything, went haywire with the COVID, and we've never been able to have the hearing. So I don't guess any attorneys have made contact with you about it.
No.
Okay. I don't know how we're going to accomplish this. It's probably going to end up having to be, something where we get George to go look for him, because I don't know where he is.
Do you want me to, I guess maybe renotice it for a Monday in May and try to have George personally give that time?
Because, he was on unsupervised, so there wasn't, really any obligation for him to tell us where he was. And when we talked to him, he was here in court after you filed your motion, and either on Zoom or in person, one or the other. But we didn't realize everything was going to go to haywire at that time. All right. So you'll just file a renotice, right?
Yes.
All right. Stephen Smith, that should have come off because the Commonwealth dismissed. This was dismissed on March the 2nd. Yeah.
He still has some misdemeanors, I think, in that. So.
Oh, you're right.
So.
He still has a driving on a DUI suspended.
Yeah.
Technically, if that's the only charge, it goes back to district court. However, he'd already entered a guilty plea to it.
Mm-hmm.
So I think it should stay up here till we sentence him.
I agree.
So we're gonna have to figure out a way to get in touch with him. Was this Josh?
Yeah, we sent him a letter several weeks ago and he's not responded. I think I even tried to call him once this past week and I got nothing. I got nowhere. I think Denise has even tried to call him a few times. I think she's so.
I've never actually spoke with him, but I have left messages at the number we have.
Well, shoot. I tell you what I'm gonna do. I'm gonna put it on like, I don't know, I'm gonna put it on for like a month from now and we'll send a notice out. We shouldn't have to work this hard to get him here, but I think you can try again to get word to him and we'll go from there.
All right.
I mean, I think
Josh,
put
do
a
you have any
warrant out on
opposition?
for 90 days in jail,
Josh, do you have any opposition to George trying to make contact with him from our
I mean,
office?
That's fine. I mean, more people out there to find him, probably better off.
Okay, Reese, just have George see if he can run him down.
Okay.
and that's for sentencing on count 2.
Did you set a date already, Judge?
I probably didn't. April 26th.
Okay.
I mean, it'll be really easy to do. You don't have to do PSI or anything because it's a misdemeanor. Charles Underhill was on here for sentencing. He was apparently out front trying to get in and the bailiffs wouldn't let him in. And we told him to call his attorney and he said he had been trying to call all last week and he hadn't got any live bodies or return phone calls. So I don't know if that's true or not true. But he said, KP told him he should have talked to his attorney and known that he wasn't supposed to be here. And he said he'd been trying. So we all know what that might mean. Might mean he called once at Thanksgiving. But anyway, I got a number. So whoever his lawyer is can get this number and try to call him. And
270-791. Write that down.
What the heck are you doing? You don't have a pen already in your hand.
I had one. I put it down.
Morse coding your notes over there?
I got it.
When are we going to put that, Judge?
Let's do the 29th of March. Okay. I think that's everybody I've got. Did you want to go ahead and pick a date for Rufus Huff, or do you want to just renotice it?
I'll just renotice it for sometime during the later part of May after we get started, if that's okay with you.
That is okay with me. My only request is to stay off on Memorial Day. Other than that,
Intention of scheduling anything for that day.
well, I mean, you might do it by accident. So I'm just.
No, I know.
I'm just throwing it out there.
Yeah.
Judge, I show a Bryant Stone on. I also know that he was in Warren County, so I didn't know if anything had been done with that.
Yeah, Warren County can't get on till 1, so we'll do them at 1.
Okay, thank you.
Yeah. And we've got a bunch of people in other jails, so I'll try to get on here, just around 1 or a little after. I mean, I want to give y'all time to eat lunch and all that stuff, but I mean, I'll start whenever everybody gets on here, but we've got Hart, we've got the, as the kids call it, the Rotary Farm. We've got Fulton, Simpson, and Warren.
Who do we got at Rotary?
Julio Alonso.
Oh, we did agree. Me and John didn't agree to order to continue that 2 weeks because I'm having communication issues with him again.
Well, did I sign it?
I don't know. I think I sent.
You sent it to me and I thought I e-filed it.
You might have. I just don't remember. I mean, was it today?
No, it was last week.
No, it was yesterday or last week, like Friday.
Friday.
Oh, well, I don't recollect having seen it, but we can put it on. We can pass it 2 weeks. We can just write it on the docket or on the calendar.
I can look and see if I e-filed it.
I think I passed it a month, actually. I think I put it on the 12th, actually, not 2 weeks. I think I put 4 weeks out.
Okay.
Your Honor, I'm going to be on district court at 1 o'clock, but we have Stephen Amston and Hart County. Greg and I have an agreement, and I e-filed those documents. So if Mike or John could stand in for me if I'm not finished with district court.
Okay, that'll work. All right, I'll see everybody in a little while. I want to ask KP if you can pull that Abston stuff off.